everybody. I am Jonathan Rosenfeld, and I am joined today by attorney Haig Himiden on the Personal Injury Podcast. Haig is an experienced trial attorney in Chicago, and I'm going to talk with Haig today about one of the major factors in personal injury litigation: pain and suffering. Haig, thank you so much for joining me today. I appreciate it.
Thank you, John. Thank you for having me and allowing me to spill a little bit more information about this very, very crucial part of what we're looking for in terms of damages for our clients in personal injury cases.
Now, in personal injury cases, we talk a lot about, getting compensation for the person. Ultimately, every single bodily injury case comes down to one thing: dollars. Okay. And, you can say, hey, it's about getting justice, but you know what justice means? It means getting full and fair compensation for your client. And when it comes to getting full and fair compensation, you know it as well as anyone. Pain and suffering is something that you deal with on a daily basis in every single case. It is relatively straightforward to take a case to court and say, hey, uh, this this is the property damage, these are the past medical expenses, this is the wage loss. But that may be, a lot of times, that may be the tip of the iceberg. Today, I want to talk with you a little bit about sort of the intangible aspect of a personal injury case, the non-economic damages, sort of the touchy-feely things when it comes to evaluating a personal injury case: pain and suffering. First off, you know, uh, can you talk a little bit about how you sort of visualize, or how you sort of describe pain and suffering to a client, to a jury, how you help convey that concept? Because a lot of times people, they have a hard time visualizing or understanding what that means.
Really, pain and suffering is such a broad term and it encapsulates so much when we're talking about how a person is affected by their injuries. And we talk about the actual physical pain that they feel, and then on top of that, everything that comes from that too, how it affects their daily life, how it actually affects their things that they used to do that they can't do the same way anymore. All of that has a pain and suffering component to it. And really coming down to being very descriptive about it is the main way I actually try to convey that out of my clients. When I'm talking about, let's say I'm preparing a client for a deposition, or if I'm preparing them for the stand, I want to tell them that, the more descriptive you are, and the way you describe it being very relatable in a lot of ways, and making it so that's very, there's imagery to it, is going to convey the message that they're trying to put out there. Because pain and suffering can be different for different people. It's very subjective. There's no objective way of looking at it. It's different on how you approach it on a case-by-case basis. And so when we're talking about, let's say, a neck injury, we're talking about actual physical pain, to be very descriptive about what it is. Is it sharp? Is it dull? Is it achy? Does it feel like somebody's stabbing in the back? Is it somebody taking a hammer to the back of your neck? Does it feel like somebody is just wringing your neck? What does that feel like? How do you convey that? Be as descriptive as possible about that when we're talking about physical pain. And when we're talking about more than that, like the suffering aspect of it, of how that's affecting their lives and how it's affecting others around them and how they react with people around them, it's not just internal, it's what other people see of them as well. So bringing in others, like damage witnesses, people that are friends, family, close family members, that can talk about, how they look, how they act differently as a result of those injuries and pain, goes a long way in really kind of describing it and making it real for somebody that's listening, like that's in a jury, for example.
Yeah, I think a lot of times when it's, if someone's sitting on a jury and, someone walks into a courtroom, plaintiff walks into a courtroom, and, they look relatively healthy. They may not have a wheelchair. They may not have a cane. They may not, have a scar, on their neck or their back. And the jury a lot of times may, they may gloss over that person. They may be like, whatever, it's no big deal. But to have someone articulate, specifics in terms of things that they can do or cannot do after an accident that they were able to do and enjoyed before, goes a long way towards, painting a picture in a juror's mind as to how the accident has really impacted them. But one of the other things that we can do as trial attorneys is we can have the plaintiff testify, we can have some of their family members testify as damages witnesses. But a lot of times, especially in a situation where someone may have a substantial pain and suffering component of a case, is getting a treating doctor involved and getting them to substantiate and articulate things from a medical perspective about what's going on in the person's body. That really goes a long way towards really getting that person full and fair compensation. When you are meeting with a client, or when you have a client who may be in a situation who they've got a significant injury, but they're having a difficult time either articulating it, or maybe they just don't understand the mechanics of it. How do you use a treating doctor's testimony to substantiate the pain and suffering component of a case?
Well, remember that a jury is the fact finder in a trial. And what they're doing is not only looking at what they're being presented as evidence, but they're also asked to test the credibility of the things that they're being presented as evidence. So obviously the person that's coming up there asking for money is going to say A, you know what I mean? And the person that's coming in, close family and friends, they're just going to back him up. So having a treating physician, somebody that's independent, that was just there, that they were referred to, that they were just doing their job in making sure that they're providing the best medical care they can, goes a very long way in substantiating that credibility of the plaintiff that's attesting to their pain and suffering. And in looking at their medical records and bills, well, not their bills so much, but their medical records specifically, because that's where a lot of the narratives are from the doctors, that goes a long way too. You see a lot of doctors asking for pain scales when they're the patient comes in and is complaining about pain in a certain area. They talk about the nature of what the patient is telling them, and they put that in their record as well. And then they use that information to create a diagnosis and a treatment plan based on that. And so the amount of pain that's being presented to them can, from the doctor's perspective, can also be, very believable or not. But at the end of the day, when the treating physician's coming in and is, taking in what the patient is saying, and then doing their examination objectively, both physical, through imaging, through testing, then on top of whatever anybody's saying, you have that science behind it to back them up.
That's a great point. One of the things that I'm sure you see as well is, when someone has an injury and maybe they have, they've tried to do some conservative treatment, and they still may be experiencing some pain. And then the doctor may, suggest a surgical procedure or something, or an injection to help alleviate the pain. A lot of times what I see is when the plaintiff either makes a decision to go ahead with the treatment or makes a decision to forego the treatment, that can also play an impact in terms of how a case may play out. I guess if you have a prospective client and they're, on the rocks, or in terms of getting a medical procedure, obviously no one wants to undergo any type of unnecessary medical treatment if they don't need it. But how do you, I guess, what do you say to a client who says, hey, the doctor suggested I do this or do that, when it comes to how it may play out before a jury in terms of pain and suffering?
Well, from the get-go, I tell clients that their medical treatment decision-making is their choice. How they feel subjectively is going to drive what the doctors are going to prescribe, what the doctors are going to recommend, and what they're coming with and what the doctor's telling them are one-on-one. The doctor's telling them what to do moving forward in terms of their medical options based on what the client is telling them. So if they're in a substantial amount of pain, and the doctor said, okay, let's do a conservative route of treatment let's try some physical therapy. Didn't help. Okay, like we did an MRI, we saw that now they have bulging discs or maybe a herniated disc, let's say in their spine, and potentially what you could do, there's different options you can go. There is the pain management route where you can get injections or prescription pills that can basically mask that pain for a while, but that there's that underlying issue, so that the doctor is actually recommending potentially they get a surgical procedure that's going to put them back in a position where that pain does not exist anymore. It's still up to the client to really decide on which way they want to go. And like you said, not everybody's trying to get an invasive procedure done if they can help it, but at the same time, it goes a long way in trusting that that doctor is not trying to lead them to a path of more injury and bills and all of that, that they're really trying to help them. And the doctors are really looking for a way and giving them options on which for them to act on to prevent any long-lasting pain. And so for a jury, for instance, if a doctor makes a recommendation and the client goes against that, I mean, for the most part, the jury may look at it and say, well, maybe they're not as badly hurt as they say they are. And conversely to that, you can have a doctor saying that, they're mostly fine, but that they're still complaining of pain. That can have an effect on what the jury thinks about that client as well, or the plaintiff for that matter. So at the end of the day, what I typically tell my clients is listen to your doctor's orders. Try to follow what they're trying to tell you, because, at the end of the day, their well-being is of utmost importance. And this case is in line with their well-being and is secondary to that. So making sure that they're getting their lives back in order and getting into a position where they're not in pain anymore and they can live the life that they were living before this injury, or the life they want to, is the number one factor that also translates very well in front of a jury.
This was great, but I think one of the things that, people also have to realize, whether we're talking about pain and suffering or any other aspect of a personal injury case, is ultimately those medical records are going to be scrutinized by an assurance adjuster, by a defense attorney, by a mediator, by the jury. Okay. And if you are non-compliant with the doctor's, orders, or, whether it's physical therapy or whatever it is, non-compliance is sort of a black mark when it comes to valuing a case, and how it, ultimately everything is your own personal decision. But if you don't do that, there's going to be some repercussions down the road at some point. So, ultimately, I think people just have to realize that and make that decision that's in their best interest.
Absolutely. And I bring that up with clients when I first meet with them all the time too, is that, I tell them that, I'm your advocate, your advisor, your negotiator. And ultimately what I'm doing here is that if you get to a point, let's say, where the doctor's recommending you do, a certain form of treatment, but you decide not to, that's perfectly fine. Like you said, it's their decision. But my job is to tell them how that can negatively impact the value of their case, and ultimately what that would do to a case in terms of value in the long run, and potentially with an insurance adjuster, or how a jury sees it, so that they have a better perspective of, yeah, okay, well, maybe I don't want to take that particular course of treatment, but that's a huge factor in how these cases end up and the results they may be looking for. And to set that expectation for them is key in the forefront. I think that really translates well for the entire course of the litigation or the claim, however we're approaching it, when the clients know that from the beginning.
Hi. Hopefully people have a better understanding right now about pain and suffering and how it may impact their case. It was great talking with you as always. Your insight was awesome. And I look forward to talking with you again in the not too distant future. Thank you.
Anytime, John. Thank you so much.
Thanks.